Good morning, everyone. My name is Victoria. I'm the intern of the legal department. I'm here today to present a briefing on the critical issue for state ocean carriage. We are facing a situation involving damaged elegant design beams, a cargo deviation clamp, and the potential implication for our P&I coverage. With that regard, this morning we are going to dive into two fundamental questions that I believe are the top of our mind. First, are we liability for this damage beam? And if so, what extent of that liability? The second question is perhaps just as importantly, will God provide coverage for this claim? These are not hypothetical questions. They represent a very real and significant financial exposure for our company. We're talking about potential nearly $1 million aspect. So let's get into it. This agenda outlines the two core questions we will address today by stemming from a critical factual discrepancy. So the bill blending specific below deck storage. Yes, our supercargo played the flat track above deck at the ball. Part 1, I will dive into maritime law, exploring whether this unauthorized on-deck storage constitutes a deviation and how the bill blending COGSA and the deviation doctrine interact to determine on the liability. Following this, a part 2 will focus on the insurance aspect, specifically reading the guard and P&I cover, most likely the CGO policy to understand the DRAN, the trigger limitation, and the dispute resolution mechanisms. So, yes. So there is six fact that matter. We took the cargo in a good condition and gave a clean receipt. The contract said below deck in writing. We carry it above deck at the above, and this is the key part. That's where the weight distribution choice, not a safety one, and below deck space were available. The salt water destroyed the finish almost the beam. The claim is for $995,000 flood related costs, and the guards had already put us on the note that it might not cover this. If you remember only two things from this slide, let's remember the contract say below deck, and we had a choice. Three things worked together here, and I will put them into order. First, the bill of landing. That's our contract and the promise in it. In the maritime law, a clean bill is accepted as a promise to carry below deck. Our actual say so in the writing. Second, the COGSA, the U.S. Cargo Shipping Statute, that's built into our contract. Normally, it protects us with a liability cap of just $500 per package because the shipper never declared a higher value. But at this of the catch, COGSA only forgive a deviation if it were reasonable. Third, the deviation doctrine. If we are unreasonable broke that promise, we lose the cap and our other protection. So this is the whole side come down with two questions. Did we divide it? And was it reasonable? On the first question, the law is well settled and it's been settled for 100 years. The U.S. court treat carrying cargo on the deck. When you promise below deck, it's just as serious as sailing the ship into the wrong place. So the Supreme Court says so back in 1923 in the S.P. John, break that promise and you protect law forward. You will pay the full value as if you personally insure that cargo. Later courts apply that exact logic into the COGSA error. On deck storage knock out the $400 cap and fibrin we can carry anywhere close, don't save you. The modern rule is narrow, but on deck storage is the one example that still clearly triggered, which is precisely what we did. So, did we divide it? Almost certainly yes. And honestly, our case is worse than the case that made the rule. In those, the promise to go below deck was only implied by a clean bill. Our writing down in plain word, we are broken. The shipper never agreed to on-deck carriage, so the law assumed below deck was a deal, and we got nothing but rebuilt that. The only way out would be argued that the beam was so unusual inside that they had to go to on deck. But our recourse killed that argument because the reason given was weight distribution, not safety. There were no safety analysis and compliant below deck space was available. That brings us to the last door, whether the division were reasonable. Because the status the forgive reasonable one, but reasonable in this case has specific meaning. It's about the safety on the ship and the cargo, but whether danger, saving life or property, not the carry or the convenience. And the status actually presume the cargo handling decision like this is unreasonable. run our fact through that test and every point the wrong way. No safety reason, no safety analysis, compliant option what we didn't take, and the writing instruction we ignore. My 100 rate is that the court find this unreasonable. So here, what this means in money. If the cap hold, we in $20,000 worth. 40 beam at $500 each. But if the division finding go against us, the cut is gone and we exposed to full $995,000 flood related damage. So this is single finding is roughly $1 million swing. We do still have levers. We can agree reasonableness, fight over how the cut is calculated, and challenge the damage surveyed and any salvage value from the beams. But realistically, the exposed is large. And that set up the real question for us. Up on that money, how much will guard actually carry? So let's move to the insurance, and I will read the guard cover the exact same way we read the liability policy. 5 4 things: what covers, what switch it on, what carve it out, and how a fight gets resolved. I will cover life in the guard club rule. The short version is the policy grant cover for a cargo claim with one hand, and for division specifically, take it back with the other. So let me show you. Start with the good news. Rule 34 covers our liability when we damage cargo by failing to store or carry it properly. Salt, water, ruined for the finish is exactly that, a storage failure. And the thing that switched the cover on is our legal liability to the shipper, which side one just established. So at the first glance, we are covered, but. And you can see it's on the right. The grant comes with the word provide that cover not include, followed by a list of exclusion. That's exactly what Gross is looking for. And two exclusions hit us, and they reinforce each other. The first one says God will never pay more than a normal carrier would have owed under the standard of international cargo rules. The second is even more direct. It excludes liability that's arrived from a division that strips us of our defense or our cap. Read that against slide one. That's our situation almost word forward. So the extra liability that division create everything about the package cap is exactly what the two exclusion are built on to cut it out. So is God right? Largely yes, but we shouldn't let them overstate it. Richard the climb into two slide, the slide up of the normal cap still cover because a compliant voltage would have all that much anyway. The slide above the cap roughly 975,000, the part of the vegetation create is excluded. This is the one bit of room to exclusion I say unless the association in its discretion decide otherwise. And that is like why God issue a reservation of right rather than a flat refusal. The door is adjusted. But there is no extra cover up in our policy that automatically buy this back. So the bottom line is that the bulk of our export is likely uninsured. And if it does come to dispute with God, three things shape how it's good. The relationship run under Norwegian law, not the US law. And if I go to arbitration in Norway, not to the US court. And there's it the pay to be paid rule, which means we have to settle the cargo claim ourselves first and then seek the reimbursement. That's matter for cash flows and timing. And it's why my recommendation is that we talk with God before we settle anything with the shipper. So let me bring to the conclusion. Because it's really one fat landing to hit. One liability, carry the beam above deck again, the writing below deck instruction is unreasonable division. So we should expect the cap to break and our exposed to run to the full value plus damage on the coverage. Guards is largely right. We insure only up to the normal cap and the division driving excess around $975,000 is excluded. My three recommendations are on the screen. First, we get into the front with God now while the discretionary door is still open. Two, we defend the underlying claim hard on reasonableness and on the damage number because every dollar we keep off the claim is dollar we not personally expose it. And three, fix the process so there's no ever again depart from the storage instruction without the document safety reasons. Thank you for listening. Do those to decide everything.